If we are ready, please, Professor Drexl, and your topic is Dynamic Competition to Foster AI Innovation, the Role and Limits of Competition Law. Professor Drexl does not need introduction. He is director of the Max Planck Institute in Munich, and he has been also president of Ascola, that is one of the organizers of this conference. Please take the floor.
Cari colleghi, cari colleghi, signore e signori, è il mio gran piacere di essere con voi, è la seconda volta che sono qui, grazie in particolare alla professora Arezzo, che è una buona amica già da tanti anni, 20 anni quasi. È sempre un gran onore, è un gran piacere di essere con voi, ma non voglio torturarvi troppo con il mio italiano arruccinato, direi. Now I would like to switch to English, so thank you very much again for the invitation. The topic that I have chosen turned out to be enormously challenging for myself. If you look at the debate on the interface of artificial intelligence, innovation, and competition law, you can find many documents that were issued by competition agencies, the competition community, international competition community at large, where you find a lot of concerns. I share the concerns, but if you try to identify a concrete competition in constraint, then the debate ends. So that the latter actually turns out to be very difficult. And I tried to find some indication, and I would like to say the purpose of this research, which is certainly ongoing, is not to identify problems where we could actually intervene. The question is to learn more about the innovation dynamics and where actually markets will move, because I think the situation has not yet been materialized enough so that we can actually identify such cases. And so maybe also my presentation will also provide you more information, and maybe that's the basic takeaway, what will maybe come in the future and where the problems may actually lie. Do we have, just to start with the first question, do we have enough innovation in the field? Of course we have. The speed of development of AI was incredible. It's breathtaking, right? So to make an argument that there are competition restraints that actually reduce the level of innovation, looking only at the past year, probably no. Where should be the problem? It's very dynamic. However, what we also see, and that's the source of the constraint, we see that the big tech companies become more and more important in the field. Remember, ChatGPT was launched not only by OpenAI, it was based on a collaboration with Microsoft. So the concern is that the big tech companies, the platform economy, will now take over the AI development, and this very much links to, one might even call it, a cultural shift. I don't want to use the term of a war of cultures, that would certainly go too far, from an open innovation model based on open source licensing, not least of foundation models, to a system where we actually will see more proprietary models dominated by those platform companies. In a few minutes you will see that I will turn a bit away because the empirical assessment will not be that clear. The entry point for my presentation, however, will be the AI Act, because the AI Act already has some indication of where the problem actually lies. OpenAI and Microsoft, that was certainly the big case, but there's another case which I find now much more interesting. That's the collaboration, again, between Microsoft and the French company Mistral. Why is this so important in the context of the AI Act? Mistral was very much supported by the French government for the adoption of the AI Act. And Mistral basically said, or the French government said, also supported by the German government, where we have Aleph Alpha, another startup, I would call it, and a large language model developer. They said, oh, the AI Act goes too far, we need an exemption. Right? We need to be supported by you, for European governments, to support the AI ecosystem. And the result is Article 3, paragraph 12, where AI systems are exempted from the application, provided that they are not high-risk AI systems, under the condition that the systems are licensed, are distributed under free and open source license. So that's the idea. Let's maintain the culture of sharing. So that was the idea. And if you go to the recitals, you find a very interesting statement where basically also again the regulation refers to free and open source licensing as a means to promote research and innovation. So the assumption is openness is better for innovation. And that is certainly the experience, because people actually went out there, even from Google, and tried to share all the information on the development of AI. The models were shared very, very openly. And the question is whether this will now change. If we look at the, and then, big surprise, even before the AI Act was ultimately became effective later this year in June, on the 26th of February of this year, we got the information that Mistral entered into a cooperation agreement with Microsoft. So Mistral may not even benefit from the exemption now. So it first advocated such an exemption, and now it might be out. And this seems to be quite clear when we look, or to some extent at least, if we look at the elements of this agreement. And here, that's, I would say, the source of the potential problem. Why are companies entering into collaboration with Microsoft? When we talk about multi-purpose large language models, those large language models are enormously complex. We need many more parameters, we need many more layers, and to develop and run such a large language model, the company is in need, especially of high computing power. And those high computing powers are dominated now by the platform economy. So in particular, Microsoft, but this could also be Amazon, this could also be Meta, so name it. We are back to the, I would call it the gatekeepers. So granting access to Microsoft's computing power, that is a very core element of this agreement. But there is another part. Also, Mistral agreed to actually distribute its upcoming new large language models, which is called Mistral Large, on Microsoft's Azure model as a service platform. So this becomes the platform for the distribution, and then it turns proprietary, right? And so that's the other feature. And there is also an agreement on joint research and development concerning the further training of the algorithm for individual customers. That's a side aspect to which I will return in also a few minutes. If we look at the larger landscape, this is a graph that I took from a report from the French Competition Agency. You see the involvement also of several of the platform companies like Alphabet, Amazon, Microsoft, and also quite important, NVIDIA, because another very critical input for the development of artificial intelligence are chips that are sufficiently performant to actually make such applications possible. And the #1 chip producer in this regard is NVIDIA. So if we don't have an assessment whether NVIDIA is market dominant in that field, I would not be surprised. But this may change over time, right? Because maybe other companies can more easily enter that market, unlike maybe when we talk about computing power. And you can also see that several of the startups that are listed on the right hand, they collaborate with several of the companies on the left hand, right, which are the holders of key input for the development of AI. The question I would like to ask, which interests me, can conduct that restricts open source licensing of foundation models be considered a restraint of competition based on a reduction of innovation, right? So that's the question. And here we have to also to look at the value stream, and then you immediately realize I only cover a part of the larger field or the larger interface of competition law and artificial intelligence. We could look at the input level. Also, the question might be, shouldn't we consider refusal to grant you access to my computing power? Can't this be considered a restraint of competition? So the problem might be exactly the opposite. So this also provides you maybe with the insight, maybe we should be happy about those collaborations. If we don't allow those collaborations, we wouldn't have the innovation in the first place, right? So rather be happy and promote such collaboration. My focus will be the central element, namely the development of foundation models that are pre-trained and can be used for many, many different kinds of applications. And then maybe another company fine-tunes the algorithm to make it more applicable for a particular customer need. That is what happens on the intermediary level. And here you actually see that with regard to the foundation models, you have two different fundamental approaches, I will call it, for the licensing. And the one is open source, and the other one might be proprietary. If you look into the many documents we now find on the interface of artificial intelligence and competition policy, you also find statements on that issue. I here refer to maybe one of the most, or even the most recent one, namely a statement by the G7 Competition Authorities and Policies Makers Summit. It shows this has now climbed very high in politics of the 4th of October 2024, so just 12 days old. And here there are two statements that are quite interesting, I will call it. On the one hand, you see exactly the same concern. We need to be concerned because of the involvement of the platform economy. So maybe because of this, we will have much more market concentration also for the development of those foundation models. And then in another part of that document, this statement also refers to the different business models. And here, very important statement, we should have both. We should not be one-sided. Maybe a statement, leave it to the market. Let's see how things develop. Right? I would also say, hey, it's a matter of the developer, what the best approach will be. From a competition law perspective, I would say, if we actually ordered parties to have open source licensing, then we would regulate the market. However, we could also still, based on that statement, intervene where actually the platform companies, big tech, forces AI developers to switch to the proprietary model, right, of licensing. That's a completely different story. And here I already add, couldn't we look at the open source licensing as a parameter of competition? Because if I offer the use of my foundation model to another company for further fine-tuning with open access, maybe then I have a competitive advantage. And if another company, like a big tech company, intervenes and forces me to actually switch to the proprietary system, we, as described here, we already limit the choice of companies concerning that mix of open source and proprietary licensing. This slide also puts water into the wine of the competition agencies. What do we mean by open source licensing? And the answer is, if I now talk about proprietary approaches and open source approaches, these are extremes. It's a scale of openness. So the question is, how open is open? Last week we had a conference at the alumni conference at our institute, and we had a representative of Microsoft speaking to us 10 minutes. I was unable to count how open. She said that Microsoft has an open policy, right? So that is what is now already called open washing. So everybody claims we are open, and you see it here. If you look more closely at the slide, it seems very complex. There are different point of references, open with regard to what, and there are the models included just as some aspects. You could also look at the data in particular, and then it's a much more complex picture. But if you take this overall, quite surprisingly, Meta is the most open company. So even the platform companies can be very open. And if you look at, that is an assessment of the Foundation Model Transparency Index, which has already been done several times. And we see that the market has become more open. So we are actually, the assumption that we are moving away from the open paradigm is not absolutely true. So also the big companies seem to experiment with what is the best model, right? So the market has not yet matured to an extent where we should actually be very much concerned. We already have a case, and in the first decision by the UK competition agency that actually looked into this collaboration between Microsoft and Mistral, and under merger control law. And actually, that's the first subfield of competition law application that interests. And here, the competition agency at the end said, we don't have a concentration in the first place. And this seems to be quite obvious, one would think, because the agreement is not on acquiring shares in Mistral. Microsoft has shares, but only 1%, right? That was not the core of the agreement. However, the competition agency went certainly much deeper into the analysis and also asked whether by other means the companies actually ceased to be distinct, as the formula is under UK competition law, which actually means to gain so-called, that's the legal test, material influence on the commercial policy of AI, of Mistral. That was the question. Did Microsoft acquire such material influence so that basically Mistral doesn't appear as a separate company anymore, as a distinct company? And this was tested with regard to the dependency on the computing power, where actually the UK agency said, hey, Mistral is also using other companies that provide computing power. It's only one company that Microsoft now comes into the picture, so there might be other sources from where it gets computing power. And the distribution agreement, very much the same. This was not an exclusionary agreement, so also Mistral remains free to actually choose a different platform. What the agency did not do, to look at in detail at the connection between the two elements. So was there actually, as I mentioned it before, was there an obligation of Mistral to actually accept Azure as a platform with a proprietary approach as a condition to actually get access to the computing power. So do we have a link? There is an indication because the Commission also said, and we didn't get all the information, under the terms of the contract, there is no concern that there would actually be a acquisition of material influence on the commercial policy of Mistral, but that was it. We didn't get information on the concrete terms. What are the terms? This was kept or considered to be obviously confidential information. So the next question would be, can we actually apply Article 101? I need to be quick here. There might be two ideas. Maybe those agreements already fall under the category of research and development agreements concerning Mistral and Microsoft. That was only one aspect and maybe not the problematic one. And to go more in the into the analysis, this may even be accepted. So as long as the result of the output or the results can be used by both companies of the research and development, we would probably not have a concern. Another aspect might be, can't we apply the regime on restrictive technology transfer agreements, the block exemption regulation on technology transfer, and maybe the guidelines. However, the distribution agreement is not a license. So even this might not work. There is the other question, whether this is upfront falling under within the scope of the block exemption regulation, because it only applies to software copyright. And that raises the very interesting copyright question, copyright law question, whether those models actually are copyright protected. And they may not be. Some people consider it simply as data, as a data set, nothing more. So there are clearly some questions. And one might think or may argue to maybe take this up also in the upcoming reform of the block exemption regulation and the guidelines. So maybe something to be discussed. The more important basis, I think, is Article 101 of the treaty itself, direct application. And here I come back to my initial statement. Why couldn't we consider an obligation to turn away from open source licensing to the proprietary approach as a restraint by object? Because it takes away, if we take the choice between the two as a competition parameter, and the two approaches should compete in the market and parties should have a choice, final users of the foundation models should have a choice between the licensing models, then maybe this is already sufficient to actually confirm that there is a restraint of competition under paragraph 1 of Article 101. The next question would be, can we enter or apply this provision below that level? Because it might well be that, after all, some company actually requires you more or less, or you will actually enter into such an agreement, and then also Mistral is ready to change its policy. Will it not turn away from its open source approach in a more general way or completely? Also because the other platforms may actually do the same. So we may gradually move in the other direction, but this would be definitely, I would think, at best a restraint by effect. So it's more difficult to argue. And if we then look at the potential exemption under Article 101, paragraph 3, we have to look first of all for efficiencies. And here, Microsoft would be required to show that the proprietary approach provides more innovation. And that's maybe very difficult, right? That's maybe not possible, and then we don't have consumer benefits. Why should such an obligation be indispensable? So probably no. And maybe the only element that would be fulfilled, I would say we still have competition, because it's a non-exclusive agreement. So this would be the only part, but where we find support for the legality of this approach. So, but at the end, maybe this may in fact be illegal. Concerning 102, we have different problems. Do we have dominance in those markets where we have many platform companies that offer computing power and where we actually have choice? It might be an oligopolistic market. So it's maybe an indication maybe we should move to the Digital Markets Act, where we don't have a provision for our case. It's not my topic so far. And maybe the more interesting part will actually be for the moment NVIDIA concerning the chip market, because maybe there we have, it's more likely to have
it's not yet a gatekeeper, NVIDIA.
Yeah.
NVIDIA is not a gatekeeper yet.
Yeah,
so
it's not a gatekeeper, no.
So
no.
I mean, you cannot apply Digital Markets Act.
You can't apply
Not
Digital
yet.
Markets Act, but it might be more likely that we can apply competition law.
Yeah.
Right? So we should not forget about competition law. Where do we have harm to competition? Do we have harm to competition? We could look at it as a trying arrangement, right? Where you have strong market power based on computing power, and then you actually oblige the dependent company to actually change its policy for licensing. I only want to indicate, and that's Peter Picht's task, I guess, that there might be other theories of harm, especially an ecosystem theory of harm. So I hand over here to Peter Picht. And then the question is, do we have an objective justification? I said it before, you have to prove as Microsoft that the proprietary approach would be the more innovative one, and that's probably not possible to make. But the core essence is we can't intervene, or we might not be able to intervene because we can't prove so easily market power, so or market dominance. The takeaway would be, yes, we have competition concerns. We should be worried. I'm also afraid that at the very end, the platform economy will dominate everything. I heard before that in corporate law we now discuss whether AI can make decisions just like directors, replace directors, but those programs would also probably depend on the computing power of those companies. So it's spreading. So what are the implications here? So suddenly we always have the big guys in the room. The analysis has to be very case specific, and for the time being we don't know enough about those collaboration agreements. Merger control law, I think, has to be applied very cautiously because startups depend on those key elements, key inputs for developing their models. And the major, or I would say the rather clear case would be one based on Article 101, namely where we have a contractual exclusion of free and open source licensing, and under Article 102, dominance might be the major obstacle. And then the next question, maybe also to be answered by Peter Picht, would be, do we actually have to reform the Digital Markets Act? Grazie mille.